Hello, this is David Olshan of Nevada Legal Services. This is part 4 of our YouTube Law School dealing with trials and hearings. So in part 4, we are going to talk about what happens when you go to court. When you go to court, you're either going to have a hearing or a trial. And those things are very much different. A hearing is simply telling your side of the story to a decision maker who is usually a judge, and they typically involve petitions for judicial review, appeals, writs, small claims actions, summary eviction. Those are all hearings. You tell your side of the story. The decision maker will either take it under advisement, which means they'll decide later, or just rule from the bench. A trial is different, and a writ, some writs do involve trials, so sometimes they're hybrid. So the rules for when you get into court and you appear before a decision maker or judge show courtesy and decorum to the other side and to the judge. Address the judge as your honor and the other party as a defendant or respondent. You don't want to point your fingers. You don't want to call people out. You don't want to be rude or express anger. Don't interrupt the judge, opposing counsel, or any witness. When the judge rules, stop talking and stop arguing because it's over, and you should accept your decision with a poker face, with a straight face, and leave. Again, showing emotion, being angry, pointing fingers, accusing people of bad things, it's not really appropriate for a courtroom, and you could be sanctioned, or even worse, the court could find you in contempt and throw you in jail. Your goal at your hearing is to prove your claim by a preponderance of the evidence, which is basically 51%, although, we're lawyers, we're not mathematicians. But basically, it's more likely than not that something happened. When you present your evidence, you can only use admissible evidence, and that is things that you have seen and experienced or other witnesses have seen and experienced. If somebody said, well, I heard so-and-so saying that Mr. X did the murder, that's hearsay. That's not something you saw and experienced. You didn't see Mr. X murder anyone. You just heard about it. That is not admissible evidence. So try to avoid what he said or she said. Talk about what you saw and what you experienced. If you're going to present your case through documents, these documents need to be identified and admitted into the record. If you're courteous to the other side, they might reciprocate, and you both can agree to admit documents into the record, and that's helpful to the court and helpful to everyone. You don't want to really argue over documents. If something is a handwritten note and you can't identify the handwriting, you might want to just give it up because it may not be admitted into evidence. Look to NRS chapters 47 through 52. They have the rules of evidence, best evidence, documentary evidence, things like that. The federal rules of evidence are a little bit easier. You just have to find them, and you're going to find most of the rules regarding evidence at a trial. And keep in mind, if you are unrepresented, if you're a pro se party, a judge will be easier on you, or should be easier on you, and not object to some minor problems that you have at your trial. If you want a witness and they don't like you and they're adverse to you, you want to subpoena them because they have a legal obligation to appear in court. The court clerk will issue subpoenas, and you can serve those on the witnesses so you assure that they show up for the hearing or the trial. The witness must have personal knowledge of something relevant in the case. When you are adverse to the witness, you can ask leading questions like, you don't like X, do you? But when it's your witness, you have to ask open-ended questions like, what do you like? So the first thing to keep in mind is sometimes the court will issue an order without a trial or a hearing. Sometimes you may lose on summary judgment, or sometimes a petition for judicial review doesn't have a hearing. So don't be surprised if you don't get to appear in front of the judge. More often than not, if a judge has a mind to decide a case, they're not going to want a hearing because it's just a waste of time. So after the hearing or trial, the judge will ask the prevailing party to draft the order, and there's no consequence for agreeing to the order, and if you have to draft it, just do it according to the minute order or what the judge instructs you to do. Judge will sign the order, and then you, as the prevailing party, have to do notice of entry of order because that triggers the time to appeal. Now keep in mind, usually there's 20 days to appeal in justice court and 30 days to appeal in district court. We will cover that in lesson 5 of our YouTube Law School. We are Nevada Legal Services, and stay tuned for more YouTube Law School lessons, one more dealing with appeals. If you want free legal assistance, go to nevadalegalservices.org and do an online intake.